The Supreme Court chamber fell into a tense silence as Justice Amy Coney Barrett leaned forward, her eyes locked on former Florida Attorney General Pam Bondi, who stood at the podium below. What had begun as routine oral arguments in a pivotal, constitutional case had swiftly escalated into a dramatic confrontation. Barrett, known for her composed, judicial demeanor, broke from her usual restraint. "Ms. Bondi," she began, her voice resonating through the hushed courtroom. "Your constitutional argument contradicts established precedent in at least 3 major rulings. I suggest you review Harrington v. Davis before presenting such theories to this court." The sharp tone drew subtle reactions from the bench. Bondi, representing a coalition of states in a high-stakes federalism case, appeared momentarily caught, off guard as Barrett continued. "Furthermore," Barrett added, "your interpretation of Article 3 jurisdiction appears deeply flawed. I'm curious, how do you reconcile this with your own prior legal writings?" What followed stunned everyone present, including Barrett herself. Bondi delivered a counter-argument so incisive, so meticulously grounded in precedent, that it not only silenced the justice's critique, but caused her to visibly reassess the advocate standing before her. Before we dive deeper into the legal fireworks now reverberating through Washington's legal circles, don't forget to like this video and subscribe for more insights into the battles shaping America's constitutional future. Justice Amy Coney Barrett had earned her seat on the nation's highest court through a blend of intellectual rigor, strict constitutional interpretation, and unwavering conservative principles. Confirmed in October 2020, the former Notre Dame law professor and Seventh Circuit judge quickly established herself as a formidable jurist with a strong textualist philosophy. Her incisive questioning during oral arguments had gained her respect across ideological lines. Pam Bondi, by contrast, forged her path through practical politics and tough prosecution. As Florida's first female attorney general, 2011-2019, she was known more for her courtroom instincts and political savvy than for academic legal theory. After leaving public office, she moved between private practice and political consulting, rarely appearing before the Supreme Court. Her appointment as lead counsel in this major federalism case, Federation of States versus Department of Commerce, raised eyebrows. Many questioned whether Bondi had the constitutional expertise required for litigation of this complexity. At the heart of the case, whether recent federal regulations had overstepped constitutional bounds, infringing on state sovereignty and taxation, and land use. The decision could redefine the federal-state power dynamic for decades. For Barrett, the case was more than a legal dispute. It was a chance to solidify her originalist philosophy during a time when the court's conservative bloc was increasingly open to re-examining precedent. With deep academic roots in federalism, Barrett saw the case as potentially historic. Bondi came to the court with different strengths. She had lived through the impacts of federal overreach as a state attorney general. Her arguments were shaped by on-the-ground experience, not abstract theory. She had spent months preparing for this moment, aware of the doubts surrounding her. The early exchanges were conventional, until Barrett's pointed challenge. Court watchers immediately recognized the significance of the moment. This wasn't just about the case, it was about Bondi's credibility, perhaps even her future in constitutional law. Barrett's unusually direct line of questioning revealed that she had detected what she believed were serious flaws in the state's position. For Bondi, the stakes couldn't have been higher. A misstep could not only weaken the case but validate critics who questioned her role as lead counsel. But beneath Bondi's calm exterior lay a depth of preparation Barrett hadn't expected, an arsenal she was about to unleash. The balance of power in the nation's most prestigious courtroom was about to shift dramatically. "Thank you for that question, Justice Barrett," Bondi replied, her voice calm and composed despite the pointed critique. Rather than appearing defensive, she neatly rearranged her notes and continued with quiet confidence. "I'm quite familiar with Harrington, and if I may, I'd like to explain why it actually supports, not undermines, our position." Barrett arched an eyebrow, her expression unreadable, but tinged with skepticism. "Please proceed." "Harrington's central holding," Bondi began without glancing at her notes, "was based on a particular interpretation of the Commerce Clause, One Chief Justice Reynolds explicitly limited to cases where federal regulatory interests demonstrably outweighed state sovereignty concerns. She quoted the key passage from memory. What's often overlooked, she continued, is Justice Kavanaugh's controlling concurrence, which laid out a three-part test to assess such circumstances. Barrett leaned in slightly, her interest clearly piqued. Applying that test to our facts reveals a crucial distinction. In Harrington, the regulation survived because it satisfied all three prongs, especially the third, which required that federal action be narrowly tailored to avoid imposing unnecessary administrative burdens on states. Seamlessly, Bondi pivoted to a lesser-known precedent. This limitation was further clarified in Westmoreland v. United States, she noted, where the court struck down federal rules that failed that same tailoring requirement, even while acknowledging the legitimacy of the federal interest involved. Justice Sotomayor interjected, "Counsel, Westmoreland was a relatively obscure 10th Circuit case, not Supreme Court precedent." "That's correct, Justice Sotomayor," Bondi answered smoothly, "but this court cited Westmoreland approvingly in footnote 23 of Montgomery v. Louisiana, specifically when discussing the boundaries of federal authority in areas traditionally governed by the states." Barrett's demeanor shifted subtly, no longer skeptical but reflective. She hadn't expected this level of case law fluency from Bondi. Gaining momentum, Bondi continued. "Now to Justice Barrett's concern regarding my Article 3 jurisdiction argument, I would respectfully direct the court's attention to an often overlooked passage in Justice Scalia's dissent in Williamson County. Although that dissent did not prevail at the time, its reasoning on jurisdictional limits in federalism cases was later adopted in Nickey v. Township of Scott, effectively overturning the majority opinion in Williamson. Barrett cut in again, this time with genuine curiosity. "Are you suggesting that Nick's holding on property rights extends to the broader federalism questions we're considering today?" "Yes, Justice Barrett," Bondi replied, "but not by simple analogy." She then delivered a sophisticated legal theory, tracing how lower court rulings had gradually expanded Nick's application beyond property disputes, anchoring it in a broader constitutional context. The energy in the chamber had palpably changed. What began as a pointed interrogation had evolved into a rigorous constitutional exchange between two skilled legal minds. Other justices began joining in, with Thomas and Kagan each posing follow-up questions, which Bondi handled with striking command and fluency. When Justice Alito raised a potential conflict with the court's recent decision in Texas v. Johnson, Bondi distinguished the cases with such precision, citing nuanced procedural and jurisdictional differences, that several justices were seen flipping through their case materials to confirm her assertions. Finally, Barrett returned to the discussion, her tone markedly altered, more measured, even respectful. "Ms. Bondi," she said, "your reading of these precedents is certainly creative. However, I'm concerned that adopting your interpretation would force us to significantly narrow our holding in Denison, which for nearly a decade has served as the primary framework for federal-state regulatory boundaries." The question was complex, technical, the kind of constitutional depth many had doubted Bondi could handle. The courtroom held its breath awaiting her answer. "Justice Barrett, I hold the Denison framework in the highest regard," Bondi began, her tone measured and respectful. "However, I would submit that applying Denison to the present case doesn't require narrowing its holding, only recognizing its inherent limitations. Limitations," she added, "that Justice Gorsuch himself acknowledged when writing for the majority." She then quoted directly from the opinion. "This framework establishes general principles for typical assertions of federal regulatory authority, while recognizing that unique circumstances may necessitate a more nuanced analysis." Bondi paused deliberately, then delivered what would become one of her most compelling arguments. "Our case," she said, "presents precisely the type of unique circumstance Justice Gorsuch anticipated, where federal regulations, though technically compliant with Denison, functionally eliminate state discretion in a way the framework never intended to allow." At that moment, the Chief Justice glanced at the clock and announced that Bondi's time was nearly up. Unlike many in complex arguments who request an extension, she chose not to. Instead, she transitioned into a concise yet potent summary of her remaining points, delivering them with striking clarity, her control over the argument absolute. As you, she began to yield the podium. Barrett posed one final question, a hypothetical so intricate and layered that legal scholars would later incorporate it into constitutional law exams. The courtroom fell silent. Observers braced for what many assumed would finally test the limits of Bondi's legal acumen. But Bondi didn't flinch. "That's an excellent hypothetical, Justice Barrett," she responded instantly, her tone composed. "And it highlights precisely the constitutional tension at the core of this case." Rather than offering a superficial answer, Bondi carefully deconstructed the scenario. She identified 3 distinct constitutional principles that would guide the analysis, citing relevant precedents for each, including several authored by Barrett during her time on the Seventh Circuit. In your 2018 opinion in Wisconsin Manufacturing, Association v. EPA, Bondi noted, you wrote that when regulatory frameworks create irreconcilable obligations, courts must examine which sovereign possesses primary constitutional authority over the subject matter. That reasoning provides a vital roadmap for analyzing your hypothetical. Barrett's expression shifted, surprise flickering across her face. It wasn't just Bondi's familiarity with her opinions that impressed, but the depth of understanding and precision with which she applied Barrett's own judicial philosophy. Several commentators would later mark this as a turning point. Barrett's demeanor shifted from skepticism to intellectual respect. And yet, Bondi continued, your hypothetical further supports our position when considered alongside an often overlooked concurrence by Justice Thomas in Department of Revenue v. McClintock. She then mapped Thomas's reasoning to the hypothetical with striking clarity, showing how his limiting principle on federal regulatory reach aligned precisely with the case at hand. So compelling was her analysis that several justices were seen, jotting down notes, captivated by the legal precision unfolding before them. Justice Kagan, renowned for her rigorous questioning, leaned in. "Ms. Bondi," she said, "your reliance on Justice Thomas's concurrence in McClintock appears to overlook the constraints later outlined in Friedman. How do you reconcile those?" Bondi responded without hesitation. Justice Kagan, Friedman's limitations specifically addressed the scope of federal authority in the context of interstate commerce. Our case, however, concerns the core federalism principle of state autonomy. In fact, she added, the majority in Friedman explicitly noted that its holding does not extend to cases where federal regulation effectively commandeers the state's administrative apparatus under the guise of coordination. And that, she concluded, is exactly the dynamic we challenge today. Kagan, visibly impressed, gave a slight nod of acknowledgement. Bondi pressed on, now not just defending precedent but charting its evolution. She traced decades of federalism jurisprudence, illuminating subtle doctrinal shifts that even many scholars had overlooked. Her command of constitutional history, both authoritative and exacting. Barrett, now fully engaged, no longer an inquisitor, but a participant in a rare and elevated legal dialogue, posed a final probing follow-up. This time, not to challenge, but to explore the boundaries of her own evolving view. Given your framework, Barrett asked, her tone no longer interrogative but inviting, how would you propose we articulate a limiting principle to prevent its misapplication in future cases? It was a striking moment, an implicit invitation for Bondi to participate in the shaping of constitutional doctrine itself. The question marked a dramatic shift from Barrett's earlier, more skeptical posture, and served as the court's highest form of recognition. Intellectual engagement. Justice Barrett, Bondi began, unfazed, I would propose a 3-part standard. She then laid out a meticulously crafted approach, one that struck a careful balance between the imperatives of state sovereignty and the legitimate interests of federal authority. Each component of the framework anticipated likely objections, neutralizing them before they could be raised. This standard, Bondi concluded, preserves the foundational principles of federalism while offering lower courts clear, consistent guidance for resolving future conflicts. As Bondi neared the end of her analysis, the Chief Justice announced that her allotted time had expired. What followed was extraordinary. Justice Barrett formally requested that Bondi be granted additional time to complete her response. A rare, procedural courtesy that signaled the depth of the court's engagement with her argument. When Bondi finally stepped away from the podium, the courtroom buzzed with quiet astonishment. Observers whispered assessments to one another. Constitutional scholars exchanged knowing glances, stunned by the sophistication of the legal performance they had just witnessed. Justice Barrett, once poised to expose perceived gaps in Bondi's reasoning, now sat contemplatively, reviewing her notes with an expression that suggested genuine reconsideration. What had begun as a routine oral argument had evolved into something far more consequential, the emergence of a formidable constitutional thinker. Across the aisle, the Solicitor General, representing the federal government, was seen hurriedly, annotating his own prepared remarks, now clearly aware that the constitutional terrain had shifted beneath his feet. Outside the courtroom, the impact was immediate. Within hours, legal blogs and academic forums were abuzz with analyses of the Barrett-Bondi exchange. SCOTUS blog, the premier outlet for Supreme Court coverage, released a rare mid-argument post titled, "Bondi's Tour de Force Reshapes the Federalism Debate," calling it one of the most sophisticated constitutional dialogues of the term. Legal scholars across the ideological spectrum found themselves in rare consensus. One prominent liberal professor tweeted, "Regardless of one's view on federalism, Bondi's mastery of precedent and theory today was extraordinary. Law schools will be teaching this argument for years." Inside the court's private conference room, deliberations reflected the day's unexpected turn. Sources later revealed that Justice Barrett openly acknowledged her earlier misjudgment. "I believe we witnessed an extraordinary display of constitutional advocacy today," she reportedly told her colleagues. Ms. Bondi's federalism analysis, particularly her proposed framework, demands serious consideration. What had once seemed a foregone conclusion now stood in question. Justices who had initially viewed the case as a routine affirmation of federal authority now found themselves grappling with a far more nuanced challenge, one articulated with such clarity and precision that it could not be dismissed. Media coverage reached beyond legal circles. Major news outlets highlighted the striking dynamic between Barrett and Bondi. One headline read, "Supreme Surprise. Barrett meets her match in Bondi Showdown." Legal commentators and cable news panels debated the broader implications, particularly for women in the legal profession. Bondi, for her part, declined interviews. She issued only a brief written statement. "It was an honor to present these important constitutional issues to the court. The justices' engaged questioning reflects the gravity of the federalism principles at stake." Justice Barrett, true to form, offered no direct public comment. But 2 weeks later, at a judicial conference, she delivered a keynote address that included a thinly veiled reflection. "The bench constantly reminds us that legal brilliance can emerge from unexpected sources, and that intellectual humility serves justice better than assumption." For Bondi, the implications were swift and profound. Law firms and advocacy organizations that had once overlooked her constitutional expertise now actively courted her for future Supreme Court litigation. Her argument had not just advanced her client's cause, it had altered the trajectory of her career and reshaped the court's conversation on federalism for years to come. In the weeks that followed, several top law schools extended visiting scholar invitations to Bondi, eager for their students to study her distinctive approach to constitutional advocacy firsthand. But the most consequential development came 3 months later, when the court issued its opinion. In a 6-3 decision, the states prevailed, and the majority opinion, authored by Justice Gorsuch, adopted significant portions of the analytical framework Bondi had proposed during oral argument. In a rare move, the opinion directly cited Bondi's responses as a basis for its reasoning, a clear acknowledgement of her influence on the evolution of constitutional doctrine. Even more notably, Justice Barrett penned a concurring opinion. There, she explicitly engaged with Bondi's analysis, particularly Bondi's application of Barrett's own prior decisions, acknowledging the strength and persuasiveness of those arguments in this new context. Legal scholars were quick to observe how uncommon such a direct nod to an advocate's reasoning is, especially in an opinion from a justice who had initially challenged that very framework. The ruling introduced a new three-part test for evaluating federal regulations that encroach upon traditional state functions, a test that mirrored Bondi's proposed approach so closely that constitutional law professors quickly dubbed it the Bondi test. It became clear that Bondi's contribution would not merely be remembered, it would be taught for generations. Beyond the doctrinal implications, the Barrett-Bondi exchange took on symbolic significance in the broader legal community. Law. Professors began incorporating the argument into advocacy courses, not only for Bondi's exceptional preparation, but also for Barrett's willingness to engage deeply and re-examine her initial stance. Together, the two jurists exemplified the intellectual humility and rigor that define genuine legal discourse. 6 months after the decision, Bondi and Barrett appeared side by side at a Federalist Society event on the future of federalism jurisprudence. Maintaining the expected professional discretion regarding the specifics of the case, both nonetheless demonstrated a mutual respect that had clearly developed since their initial courtroom exchange. During the discussion, Barrett offered a pointed reflection. The most valuable moments in constitutional development often arise when our assumptions are challenged, especially by advocates who bring different perspectives and life experiences to the law. Bondi responded with equal candor. The strength of our legal system lies in its capacity for rigorous debate, regardless of where the ideas originate. When advocates and justices engage in good faith, our constitutional principles become sharper, stronger, and more resilient. For many observers, the lasting impact of the Barrett-Bondi encounter extended far beyond the decision itself. It stood as a powerful reminder. In the realm of constitutional law, the advancement of understanding depends not just on intellect, but on the willingness to listen, to reconsider, and to learn, even at the highest levels. In legal circles, the phrase "pulling a Bondi" entered the lexicon, used to describe moments when an underestimated advocate displays unexpected brilliance, altering the trajectory of a case, or even the law itself. Justice Barrett's openness to re-examining her position only enhanced her reputation for intellectual integrity. She had demonstrated that true judicial temperament includes the humility to revise one's views in light of persuasive reasoning, an act as courageous as it is rare. Ultimately, the Barrett-Bondi moment reaffirmed a foundational truth about constitutional advocacy: that the most enduring legal progress doesn't come from affirming what we already believe. It comes from the thoughtful, rigorous challenge of those beliefs. Thank you for watching our detailed analysis of this extraordinary Supreme Court exchange. If you found this breakdown insightful, please like the video and subscribe to our channel for more in-depth coverage of the constitutional battles shaping our nation's future. And don't forget to hit the notification bell to stay informed on the legal developments that deserve your attention, but too often go unnoticed.